Well, I guess just in the matter of time, I can go to explaining the bill, if you'd like, or I can open it up to, I have two
There are
gentlemen
no
here with me.
questions. I think you've kind of explained it. Your amendment does a lot of what the
It
bill
really
does.
does, yeah.
And so we have, I don't know who wants to go first. Larry Freeman, you want to go first?
Yeah, thank you, Mr. Chairman. Larry Freeman, Chief Deputy Attorney General. The genesis of this bill, as you may be well aware of, the issues that we've seen over the last year of juveniles out on ankle monitoring. The monitor becomes uncharged or they damage it, and then going out and committing some heinous crimes. So that kind of spurned the Attorney General to look into this a little further and to then wanted to beef up the consequences and this particular statute to where making these folks accountable and having consequences for them not complying with the conditions of their release on a monitor. So I just wanted to let the committee know that's the genesis of the bill.
Right. The murder in front of Dickie Brennan Steakhouse kind of comes to mind.
That was one of them, yes.
In any event, Mr. Walters, you want to testify as well?
Thank you, Mr. Chairman. Christopher Walters, Deputy Executive Counsel for Governor Landry. We wanted to thank Senator Cloud for bringing this bill and thank the Attorney General for her work and support on this important issue. And just kind of echo those thoughts from the Attorney General's office. The governor is extremely concerned about these prior instances that we've seen that have made the news with ankle monitoring where it's gone wrong. And we know that there are fixes and things that need to be done, and we think this is a good first start. You know, Senator Cloud always does her homework, and she's always listening and working with everyone involved, and so we will continue to do that as we go forward with this thing. But just something to kind of put in your mind is that electronic monitoring is a very important and powerful tool in our criminal justice system to be able to allow defendants to be able to keep going, keep a job, keep going to school, keep going to work while they participate in this process. However, it is an important tool, but it is a privilege, and we need to make sure that we remember that it is not a right. No one has a right to be put on ankle monitoring, so we want to make sure that those individuals that are on ankle monitoring, that the process and the system is working as it should, that those violations get noticed quickly to all of the appropriate entities that need to take control of it, and that those that abuse that privilege of being placed on ankle monitoring are dealt with in the appropriate manner. So we thank y'all, and we are in favorable passage.
Okay. Senator Abraham does have some questions, I believe.
Thank you. Okay, it says that, and I guess that's normal procedure, that the cost of the monitoring is borne by the person being monitored. Is that current law, or are you changing that? It's on page 2, part B, electric monitoring program. The cost for participating in an electronic monitoring program shall be borne by the person being monitored.
Senator Abraham, some jurisdictions, some areas, they do, and that's more so on the adult side, especially in Orleans parishes, I think it's ASAP or something like that. The defendant would bear the cost as an adult. In the juvenile world, we're not so sure that is being applied. So what we wanted to do...
Didn't you say you could waive it as for juvenile?
Yeah, so what we did is, at first it said by the person, then we changed it because of a juvenile, it would be their parent. We wanted to make the parents have some skin in the game. Of course, if they can't afford it, as Senator Cloud said, the court has the right to waive that cost and absorb the cost by OJJ or the court.
Yeah. Well, I was looking on, I know this is not the, just looking on the physical note there. So the fees, that it says that there's some monthly fees or whatever, that will be borne also if by that person, these fees that, what did it say here?
Yeah, go ahead.
Additionally, OJJ would be incur costs to include electronic monitoring fees to the counting area of the juvenile electronic tracking system for the development of testing and implementation. So evidently, there's some fees there, but
That would be some cost in that OJJ would incur by being the collecting agent.
if it was not a juvenile, an adult, who would pick up those fees? Does the does the person who has the monitor would have to pick up those fees also?
That's correct. If they're an adult, they would be assessed the fee for monitoring for pretrial, and then for post-trial, if they were on probation with the Department of Public Safety and Corrections or parole, and they had a monitor, there are fees associated with that the participant is responsible for.
Yeah. Okay, thank you, appreciate it.
Thank you, Senator Abraham. Senator Barrow.
Quick question as it relates to children, juveniles, to be detained up to 6 hours without judicial oversight. I think I see this on page 2. Currently, OJJ protocols already allows for on-site device exchanges. Is that true?
I don't know if OJJ is here to testify to that. What we
Okay.
did, but I can testify to what the bill does. The bill, whenever someone is entering into the electronic monitoring program, they give consent for a period of detainment, and that's how the bill reads, up to 6 hours for repairs, charging if there is an issue, and it shows some issues on the monitoring tracking system that they're able to take the individual wherever would be the designated place. Maybe it's the local law enforcement, maybe it's an OJJ intake facility, and charge the monitor or repair the monitor for them.
Okay. I'm gonna need to get further clarity. Is anybody here from OJJ? No. Okay.
What is happening now, as you probably well know, is if the monitor goes down, there's no real mechanism in place across the board that is being used to go out and pick the person up and get it fixed. The person who committed the murder that Senator Morris talked about, his monitor was dead for 30 days. And so no one went out and did anything. So what we're doing is we're trying to put some more teeth into this bill to say if it goes down, they can go out and pick them up, bring them in, and fix it immediately. So we're trying to get some immediate action by the providers as well as law enforcement on handling these cases where the monitor is either uncharged or broken or tampered with, to try to avoid some of these problems that we've been seeing.
Okay. Thank you, Mr. Chairman.
Thank you, Senator Barrow. The board is clear. We do have some more cards in support. Not wishing to speak, Jill Dennis, Association of Supervised Ankle Monitor Providers. In support, Zach Daniels, Louisiana District Attorneys Association. In support, not wishing to speak, Dwight Hudson with Right on Crime in support, and as well as Susie Library in support, none of which want to speak. In opposition, we do have Cater Hunter Lowry with Vera, Louisiana, wishing to speak in opposition. It's the only red card I see. Okay. Did we miss our red card on?
Green card, it was the first one, and it said wish.
Oh, you wish. Oh.
Yes, sir.
Oh, okay. Okay, I'm sorry. Yeah, you're right, Jill Dennis. I'm sorry. You do want to speak. My apologies. Maybe that was wishful thinking. Just move along. State your name and give us your testimony, please, ma'am.
Jill Dennis, Vice President of the Association of Supervised Ankle Monitoring Providers. First, I want to say we're in full support of this bill. Thank you, Senator Cloud, and I want to thank the Attorney General's office for working so hard on this. Creating rules for the court is another thing that this bill does when an offender violates his or her conditions of release. We'll do a lot to protect our community and ensure that those that are in violation cannot continue to commit crimes and create more victims. The majority of the judges we work with daily do not allow violation reports to go unnoticed. The process is normally taken is when an offender violates a condition set by the court will contact that counsel or contact the supervision provider and ask that offender to be brought into court. If the offender fails to appear, the judge will issue a warrant. However, if the offender does appear adequately, the judge will listen to the offender and determine if the violation is excusable, meaning we need to extend the curfew conditions because they get off of work later, or they had a issue with their family that caused that violation. The judge will then talk with the offender or reset the conditions to make it to where that offender is not in violation. However, for those that blatantly disregard the judge's orders, they are remanded for a number of days and then released. This process allows the judge the ability to punish the offender, and hopefully when released, the offender will follow the rules that are set by the court. However, in some instances, our communities are forced to live in unsafe conditions due to the inaction of our judges. Like in the case of Nicholas Marana, accused of shooting 4 people, killing one of them in broad daylight in the city of New Orleans, while wearing a GPS monitor. I will tell you, because of the offender management system, crime cameras, and the work we've done with NOPD, this offender was quickly arrested. However, Mr. Marana had 41 violations after only being on ankle monitor for 60 days. The judge's failure to act allowed the opportunity for an offender already accused of negligent injuring, discharging a firearm during a violent crime, felon with a firearm, and other charges, not only to re-offend, but to take the life of 27-year-old Yasmin Webb, and forever change the lives of 3 others that were shot. The failure of the court to react to violation reports caused this tragedy. Had we already had a law like introduced here in SB 95, Ms. Webb may not have been killed, and the court would have not had 3 more violent crime victims. I think my only concern with the bill was corrected in one of the amendments where it was daily violation reports. My concern was 450 compliance reports mixed in with violation reports to a district attorney's office could cause a problem. We worked with the district attorney's offices across the state, and our standard reporting process is violation reports get sent within 24 hours, and then court reports the day before every court date is sent that list all the violations from the last court date. I did have a little bit of a concern with one of the amendments that changed the GPS provider to law enforcement agencies for the detainment. The majority of our adults that are monitored in the state of Louisiana are monitored by private providers. Changing that language to law enforcement agencies does not allow us to be able to detain an offender that needs help with their device or to charge that device. And I think we fixed that at the last session because a lot of our laws said law enforcement agencies. However, that law would mean I can't detain an offender that is failing to charge and make them charge their device. So that was my only concern. Outside of that, again, thank you, Senator Cloud, and please vote yes on this bill.
Okay, the board is clear, and we do have, now we have 4 cards in opposition, so if you all would come up at least 3 at a time. Katie Hunter Lowry, I don't see